course, this is some legal challenges. And from what I've heard so far, I can only imagine the wealth of legal challenges that lays ahead of us. But today we're going to address some of the most pressing legal challenges. I am Inge Holberg. I'm a professor of European Union law at Ghent University, where I'm also director of the Ghent European Law Institute, and I'm director of the European Legal Studies Department at the College of Europe. Now you're going to say I didn't hear China from that. Don't worry, the panelists are the people that matter, and they're all experts on China. So, without further ado, talking about legal challenges, we of course want to talk about regulation and litigation. We will start with regulatory aspects, and we have an expert here sitting next to me, Dr. Aaron Haningwa, I'm sorry about the mispronunciation, from New York University, who also has a very strong practical insight in all matters related to employment law and social protection issues. We already heard this morning by Professor Fabienne Bossert that there are indeed issues relating to social protection, also environmental protection. Environmental protection will not be the focus of the oral talk, but social protection will. I'm glad we gave you the floor.
Thank you. Good afternoon, everyone. I want to say a special thank you to the Leuven Center on Global Governance and my friend Professor Karai for having me here in Brussels with you all. I do have to make a confession. I am not actually a doctor of any sort. Medical, to my mother's disappointment, or in academia. I do have a JD. I'm a practicing lawyer, but also have spent a lot of time living in China and studying labor issues involving China. So I have the tough job of being the first speaker on a second panel with no coffee break in the middle to separate the two. And so I decided for my presentation to do something a little different, also using more of an inductive method. Instead of setting forth a theoretical model of sorts and saying why my one case proves all those points correctly, I'm going to talk about a specific case, which I think will illuminate a lot of the themes that have been discussed today about BRI, and mostly let you make your own conclusions, but just offer a few thoughts at the end. So the first question I did want to ask, has anyone in the audience actually heard of Saipan or know where it is? Okay. 2.5. Well, that's probably a good place to start then. So that is the island of Saipan. It's a part of a Commonwealth of the United States. But as you can tell, it is geographically and sometimes in many other ways a lot closer to Asia than it is the United States. So in terms of relevant history, I think Saipan was under Japanese control for a long time. After the Second World War, became somewhat independent, but under the U.S. sort of protectorate. Eventually, through an arrangement that was negotiated with the U.S. Congress, became a Commonwealth of the United States. There was a period for a long time where part of that negotiation was that U.S. federal labor laws would not apply, and that Saipan would retain control over its own immigration policies. And the most notable piece of history for our purposes that I'll mention is there was a period in the 1990s and 2000s where the United States still imposed quotas and tariffs on lots of textiles. So even though other countries could produce textiles much more cheaply, because of the quota system, Saipan was able to enter the picture because they needed just other places to make garments. And Saipan, not using US federal minimum wage, but being able to call their products made in America, developed a very large garment industry with tens of thousands of workers. It was eventually exposed that what was happening there was horrible, almost slave-like conditions where they would bring in people from China, the Philippines, and other countries, working under pretty terrible conditions, living in barracks where they were not allowed to leave, their passports and other documents were confiscated, paid less than even the local Saipan minimum wage, never paid overtime, et cetera, et cetera. All of that was exposed There was a lot of litigation. The U.S. Congress got back involved. They said, we're taking control of immigration to some extent. And the Saipan economy took a real hit. And fast forward 20 years, the pension was in trouble. The government had very little revenue. And they decided that they were going to legalize gambling on the island. And they put out a bid for an exclusive operator, a Hong Kong company, arguably through quite corrupt means, got that exclusive contract. And what they decided to do to build the casino was that they brought in really 4 or 5 major Chinese contractors to do the work. And this included state-owned enterprises, it included enterprises that are publicly traded on Chinese stock exchanges, it included private Chinese enterprises. And what we saw in terms of labor conditions was almost a repeat of what had happened during the garment industry. So the way that people would get there was all sorts of recruitment of workers from China. A few of them did have formal legal guest worker permits, but the great majority were recruited through means like this, on WeChat or Weibo or other means where they're talking about, the type of workers that can apply. They promised them great jobs in America, all of the money they would make working 8 hours a day, and the overtime they would get after that. All sorts of completely false promises were made, such as that they could get an American green card, they could stay in America as long as they wanted, and that no visa was required. Which is sort of a half-truth because Saipan is one of the few places that Chinese can travel without any visa, but to be tourists for up to 40 days. So they would coach the people after they took often very large recruitment fees from them, then they would get to the airport and they would say, oh yeah, but when you get to immigration, make sure you tell them that you're here for tourism. And they would get into Saipan, the very next day they would appear on the construction site and be put to work. And so I went out there through a sort of funny, somewhat convoluted story that perhaps I'll save for the cocktails later on. But what we found was the conditions were quite terrible, right? I mean, the housing arrangements were quite bad, toilets that nobody would want to use, food that was being served had worms in it. People were working 13 hours a day in the hot Saipan sun. They weren't getting paid federal minimum wage. They were not getting paid any overtime whatsoever. Health and safety on the site was horrendous. But not only were the conditions, did a lot of workers say that the conditions on this site were worse than the construction sites that they had been on in China, the Chinese companies, because they were illegally employing people, would not report any injuries to the hospital. Instead, they would either tell them to stay in the dorm and try to get better or to send them back to China. And so what was eventually found when all of this started to unravel was that there had been up to 70 different serious injuries to workers in the year 2016, but about 2 of them had been reported to OSHA, which is America's federal regulatory body for occupational health and safety. This is just some more images of the workers on the site. This is a picture that was taken, one of the companies where they were confiscating people's passports, which if you read the laws or international literature is sort of one of the large red flags for human trafficking and forced labor. One more way in which the workers felt coerced to continue working under these conditions, so you don't even hold your passport and cannot travel essentially without your employer's permission. So what basically happened was, this summarizes some of the issues we talked about into what was happening on the site. All of it came to a head when a worker fell and died, one of the few deaths that did happen on the site, at which point we had been working with the FBI and the Department of Labor to give them information about what was going on, and that prompted the FBI to finally go in. They actually confiscated hundreds of passports that were being held by the employer. It started a process with the Department of Labor to negotiate for the back wages. About 5 or 6 different Chinese managers were arrested and went to jail for violating employment laws and immigration laws. And the other thing that happened was in terms of workers getting their pay. So after the FBI came in, The Chinese companies, not surprisingly, were trying to get all of these 2,500 or so Chinese workers. Keep in mind about 2,500 workers on an island that only has about 40,000 residents. Tried to get them all to go back to China as quickly as possible, but a lot of them who had not been paid refused to go back until they were paid their compensation and started to protest outside of the casino. And this went on. There were different groups that would keep popping up, and they would get paid through the Department of Labor. They would go away. Another group would pop up. They hadn't been paid, and so the companies would come forward and try to pay. Eventually, the Department of Labor did reach settlements totaling about $14 million for these, $14 million for about 2,400 of these workers. Like I mentioned, OSHA came in and fined the companies after finding 20 serious violations, about $200,000, which sadly for OSHA is a lot of money. Like I mentioned, people went to jail and the USDOL settlements. So obviously a lot there, a lot of different aspects. Just a couple of points that I will throw out, and then happy to take your questions after that. I think, one of the sort of questions I think that comes up with Belt and Road in looking at the labor side is, are they creating opportunities for local workers? So, people have this image of these state-owned projects, state-owned enterprises doing infrastructure projects where they bring in thousands and thousands of Chinese workers. McKinsey came out with a report that said actually that's not the case, at least in Africa. 90% of the employees are actually locals. I think it depends where you look. I don't think the answer is simple. Certainly in this case, about 100% of the construction workers were Chinese. I think one of the most interesting things is there's actually local law in Saipan that requires a certain percentage of employees to be local. And there was even a provision inside the contract for the casino that requires a certain percentage to be local. However, waivers were then issued by the local government to allow basically an exclusively Chinese workforce to come in. A similar thing happened in the Bahamas where they also built a casino where law required 70% of the workers to be local. When a Chinese state bank came in and said, we're going to finance this project, they insisted that that provision be waived and they'd be allowed to bring in also an almost exclusively Chinese workforce. But an interesting way that I think, in certain cases at least, the Chinese state and Chinese actors are actively sort of undermining some of these policies that seek to protect local workers to bring in Chinese workers. Another point is, so what is BRI going to mean? Is it going to mean a rise in labor standards, or is it going to be a sort of driving down of labor standards? Obviously this is one case, but I think, at least looking at the evidence here, there's nothing to show that it's raising them up. This was a case where the companies very willingly violated existing federal laws, existing local laws with total impunity, really making no effort at all, I would say, to comply with U.S. overtime rules, U.S. health and safety rules, and quite to the contrary, actually withholding information from federal authorities and trying to obstruct investigations by federal authorities into what they were doing. Another related question is, and sort of hypothesis, well, would state-owned enterprises be better, right? Shouldn't they treat maybe workers better because they're more closely tied to the state, and at the end of the day, maybe Belt and Road is really about building soft power in China's political mission, at least as much as it is about economics. At least in this case, there was no evidence that the state company really operated any better. They were actually all living in the same dormitories, subject to the same policies. The state company was the one that had confiscated the worker passports. So I wouldn't say this case offers evidence that state-owned enterprises were behaving better. Finally, an interesting point is, so how do we, in this case, you could argue that there was some remedy for the workers, right? At least they got their money back, plus the recruitment fees. So what allowed that to happen in this case? And does that exist in other areas where, Belt and Road is operating? In my view, there were two key things that allowed it to happen. The first was that, for whatever reason, the workers in this situation once they started to protest, even though they were no longer legally, or were never really legally working or legally present in the United States, were allowed to stay there and protest, and were not immediately deported, which is something that happens, with quite some frequency in the United States, right? The employer often tips off the government very quickly, says these people aren't documented, you should get rid of them, and sadly that happens pretty often. And what that then triggered was a whole lot of media coverage, right? So the slide I had before, when I talk about, showed the New York Times, Bloomberg, Reuters, the Financial Times, were all reporting on what was happening in Saipan. And it looked very bad for these companies, and I think probably very bad for China to see this type of abuse happening along the Belt and Road. Obviously, the sort of freedom of the workers to protest, to freely associate, freedom of the media to report on these things is not present in every country. And I think that's going to create quite an obstacle for workers in other parts of the world who are subject to similar abuses to be able to get some sort of remedy. And as two quick final points. The first is, even though there was no difference in my mind between the state-owned enterprises and the private ones in this case, and it seemed like reputation and soft power didn't really matter much, at least in how they were behaving at first. I think the evidence is that these things did matter to all of these companies once the sort of violations were discovered, right? So once kind of the media got involved and made it clear what was happening, all of these companies quite quickly actually settled their claims and probably paid even more money than they were necessarily legally liable to pay in order to sweep this under the rug and sort of put out the fire. And the last point is, what does this have to do with the Belt and Road? Because American Saipan is not even part of the Belt and Road. And I think one interesting thing is that all of these three companies, despite that fact, in their own announcements and press releases at the outset of the projects, talking about, we're investing in Saipan, all of them call this part of their Belt and Road initiative, how they're supporting the Belt and Road strategy, which I think speaks to some of the themes that came up earlier about what is the Belt and Road, how is it defined, what are the parameters. I think companies and local actors are sort of using it for their own purposes, right? They want to classify everything that they do that's outward bound as part of the Belt and Road. So I will end there and look forward to any of your comments and questions. Thank you.
Thank you. I can imagine that there's going to be a lot of questions on this paper. But we first go to the next paper by Dr. Wei Yin, who's lecturer at the Southwest University of Political Science and Law in China. And Dr. Wei Yin will talk to us about dispute resolution. So we already tackled the litigation aspect. And in particular, she looks at implications and challenges of a Chinese model. Dr. Wei Yin, you have the floor. If I can ask you to stick to the 15 minutes, as well as the next speakers, because we are running a bit behind.
Okay. We really listen a lot of presentation today about economic and broad picture of BRI, and now I will discuss and also introduce the Chinese latest approach to dispute resolution. And I will divide my presentation into three main parts. And I will talk about the motivation behind the Chinese models, and then I will briefly introduce and analyze the framework of the Chinese models, and then I will discuss the internal and external implications and challenges of these Chinese models. And firstly, the Belt and Road, from my perspective, is not a China-only proposal. It's an open proposal that invites all countries along the Belt and Road to participate. And nowadays, we can show that with the development of globalization, and also due to the result of financial crisis, there are a lot of disputes between trade and investment, dispute between private entities, and also between government, and even between the host countries and investors. So now many countries try to step into a competition to establish a kind of dispute resolution body that's specializing in international commercial dispute resolution, and especially some like Asian countries and also some in Europe countries. And among these few, there are also other arbitration institutions that try to reverse or improve the rules to attract other clients to choose them as a forum to address in commercial or even investment disputes, such as the ICC and the Singapore and Hong Kong international arbitration centers. And under this circumstance, China, as a supporter of Belt and Road Initiative, also want to provide his own proposal or his own model for dispute resolution among the Belt and Road, especially commercial disputes. And here I highlight two documents in relation to Chinese models. And the first one is opinion. This opinion is released the beginning of this year and try to guide how China will build its dispute resolution mechanisms. And the second one is the provision, or we can say the regulation specific for the Chinese International Commercial Court that was recently established in June, and also it's come into effect last month. And in terms of the motivation behind the Chinese approach to the dispute resolution, I identified three main reasons. The first one is more political oriented actions. As I said before, the Belt and Road is initiated by China, so China wants to provide its own solution approach to support the Belt and Road to have it operate smoothly, because it is a very large initiative which covers a lot of different kinds of projects. So the dispute is inevitable. So that's why China wants to provide one for political consideration. And the second one is more from a legal perspective, and it is also a chance for China to get involved in a more international, we can say, or competition, or also the cooperation between different litigation and also arbitration and even the mediation institutions. And it provides China a chance to deeply and further its domestic jurisdiction reforms. And the second one is from a more economic perspective, because China, and as many presenters said before, many Chinese investors, especially state-owned investors, get involved in this kind of project. They try to provide Chinese investor a platform to help them to address those disputes. And China also wants this proposal be an international one to attract foreign clients to use this Chinese model to address disputes. And then let me briefly introduce the framework of Chinese model. The Chinese model, in my paper, is can be understood from two perspectives. The first one is, as I said before, the international commercial dispute commercial court, and second one is China tried to use this opportunity to build a one-stop center which combines litigation, arbitration, and mediation. So the opinion I said before emphasized that if China wants to establish that kind of dispute resolution mechanisms, China should follow these principles and to help build a diversified dispute resolution mechanisms. So Based on this, China International Commercial Court was established in June and its very latest actions. But although it follows the trends presented by many other countries like Singapore or Dubai, they also established their international commercial court. But Chinese international commercial court possesses some Chinese characteristics. And there are two courts which was established. The first one was established in Shenzhen, and the other one was established in Xi'an. And their operation are limited or constrained by the regulation I said before, which is specific for the International Commercial Court. It just come into effect last month. And the other thing I have to mention here is the judge. And now we have 8 judges appointed by the Supreme Court of China. They have a lot of experience in commercial dispute resolution, and they also familiar with international rules and the customary international principles. And they are well experienced judges. But now we only have 8 judges, and they can use they can speak both Chinese and English. So Chinese and English can be their working language. And I want some pictures from the official website of the China International Commercial Court. So I will not explain more about the jurisdiction, the scope of the jurisdiction, but here I have to emphasize is the first one, and it's a feature and also an innovation of the Chinese models, and because we know that it's a Supreme Court of China, so it allows the claimant, or we can say the parties, to have agreement and to let the courts to hearing their dispute. So the party autonomy was emphasized here. And other things, you can just take picture or search from the website. I will not explain more. And then the other thing I have to mention here is that it's different from maybe other commercial courts, but the international commercial cases in China just means we can say it's a civil or the commercial dispute, but not the investment dispute. And these cases should have following elements, but these cases should have actual connection with China. And I explain more here, and this means that under the jurisdiction of the China's International Commercial Court, the dispute between government is excluded, and the dispute between investor and state is excluded. So it's only focused on commercial disputes. And the website also highlights some features of the China International Commercial Court, but I will only select 2 that I will explain more in the following slides. And the first one I want to emphasize here is the International Commercial Expert Committee. The first batch of this committee members just released last Sunday. They are 32 domestic and foreign experts from the countries along the Belt and Road route, and they are expertise in the legal experts in their jurisdictions. And the function of this committee the functions of these committees comes from 3 perspectives. The first one is they will provide legal advices for the judges of the commercial court, and the second one is they will help the judges ascertain and translating the foreign laws, and the third, and I think is the most important one is they will be entrusted by the International Commercial Court to mediate and dispute because now the most important things and emphasized by Chinese part, we can see from some news or the official document, they emphasize that the most important function of this committee is at present is mediation. And I heard from my friend who is working on research about the committee. He told me that China is working on the mediation rooms about this with the resolution, and maybe will be released by the end of this year. And the other innovation I have to mention here is, or we can say the tripartite dispute resolution mechanism, or one-stop center, or we can say the Trinity system. China intends to collaborate to combine the litigation, mediation, and arbitration among in these one-stop centers, and I think is the one-stop center based on the International Commercial Court. And according to the regulation for the International Commercial Court, it's mentioned that the relationship between the mediation and litigation, and also the arbitration and arbitration and the litigation. If those parties choose mediation, the commercial committee and the expert committee will be entrusted by the judges of the court, or other mediation institute will be chosen by the court and to mediate the dispute. And if the parties have agreement on mediations, they can ask the judges, or we can say the court, to issue a conciliation statement or make a judgment according to their consent. And when we turn to the arbitration and the relationship between arbitration and litigation, a party can choose arbitration, but it's, I think from my perspective, it's not the arbitration institute outside of the court. Maybe it's the arbitration institute as a part of this court, but since it's still not very clear, so we still have to wait new things and new rules in the future. And in these systems, the parties can ask the court for setting aside a word, or for enforcing those awards. And in my paper, I think the most important thing is not just to know the framework, because the framework is very basic things, and there are a lot of rules we cannot see, and detailed regulation and still maybe in discussion or in preparation. So we have to ask questions on this current framework. From my side, there are internal difficulties and challenges, and also external. I will discuss later. From the internal side, the first thing I think is that we only have 8 judges, but these judges are also judges of the Supreme Court of China. So, is there any other research and translation system for them to dealing with these cases? We don't know at the present. And then, in terms of the case hearing, now China adopts a judicial accountability system. I was just wondering whether this kind of case addressed by the International Commercial Court will be referred to other professional committees of the Supreme Court of China or not is still unclear. And the third one is the relationship between arbitration litigation and between domestic institution and the foreign institution. I mentioned this one in the innovation part. Even though it's an innovation, there's still other unclear clear things that other people should know. The first thing is whether they will only choose domestic institute with international focus, or they will choose international institutions, arbitration or mediation institutions from other countries. Is still uncertain. And the last, and the other things I have to mention is interim measures, because if you want to have the arbitration as a part of the court, and the court will help you to preserve the property or the evidence, but only if those arbitration institute as a part of the court. So we still have to the question whether those kind of international arbitration outside of China can do the same things. And the last challenge, I think, is enforcement of the judgments in foreign jurisdictions. Now, and China is trying to sign an active agreement with other countries, and also sign the memorandums with other countries for judicial assistance. And China actively negotiating the higher convention on reclamation and enforcement of foreign judgment, and it has already signed but not ratified the higher convention on choice of court agreement. From the external perspective, here I want to mention is maybe the competition between China's court and other commercial courts existed or will be established in the future. So they already have a very famous one in London. London have its UK have its very famous international commercial court in London. And there's another one in Asia, it's Singapore International Commercial Court, and they are also one in the Gulf Coast. They are also in international commercial courts in Gulf countries, and many Europe countries also plan to establish their own international commercial court to attract more claimants to use their litigation or legal systems. In comparison with China's model, they share some similarities, but they also possess their own distinct characteristics. Here, different from China's model, those kind of international commercial court, they will or have already undertaken legislative reform to support the operation of their international commercial court. And the second one is they have broad scope of jurisdiction, because many of them do not require the actual connection and elements for jurisdiction. But China, as I mentioned before, because the Chinese law, so those kind of cases or disputes should have actual connection with China. But in the future, we don't know if there are any legislative reform in China. But now, no. And the third one is China. In the previous picture, it shows China adopt first instance being final, but other commercial court they choose and the second instance being final, but it's totally different. And the first part is those international commercial court emphasize their link or relationship between litigation and arbitration, but the innovation things is from the China side, because China try to link mediation with litigation and also the arbitration. So that is the innovation part of China, but other courts have not adopted this approach. And the last one is enforcement of those judgments, because many of these courts were established in common law countries, so they they can police of the barriers for an enforcement of those judgments compared to civil law countries and also compared to China. And apart from those...
Can I ask you to conclude?
Okay, just two sentences. Apart from the competition, or we can say cooperation with other commercial courts, there are a lot of other very famous or also international arbitration or mediation institutes that want to get involved in Belt and Road. They poison themselves as attractive platform for the parties to address dispute resolution. So for China, I think the Chinese model, even though it has some innovations, but still a lot of things that have to be clarified in the future with rules or regulations, or even some complementary provisions for the operation of Chinese models. And the other things, I think, not just China and maybe other countries that want to participate in Belt and Road initiatives, they should find a way to cooperate and coordinate with other institutions among the Belt and Road initiatives, because I think from my perspective, there is no one-fit-all approach at this moment, but there could be cooperations between those institutions, and maybe in the future the market will tell us which one the claimants or the parties will choose to address their disputes. Thank you very much.
Thank you. You explained a very difficult and complex matter in a very short time. I'm sorry I had to interrupt you, but then perhaps during the discussion, maybe you can fill in what you have to leave out now. Now we go to a complementary talk, I think, where we zoom in on the role of the Chinese Supreme People's Court with respect to arbitration enforcement mechanism. And we have with us Mr. Kun Hui, who will present his PhD research, I imagine, or is it extra PhD?
Well, so this is our co-authored paper.
Your author paper. And together with Mrs. Yasmin Nandao, who's a specialist in construction litigation and international arbitration. You have the floor. You wanted to make something.
Yeah. Thank you so much to the panel and to the organizers of today. We really appreciate having this opportunity to talk about our common interests here. We're going to, as Ingo said, sort of zoom in on one particular issue when it comes to dispute resolution for the Belt and Road, and that's investor-state dispute settlement, or ISDS. And there's a number of reasons why this is so important. I'm sure you can think about different elements of why that would matter, but three we want to highlight here are that the ISDS is critical for BRI parties because of the differences in their legal traditions. If you have Tajikistan, Poland, Eritrea, China, and Singapore in a room, you can imagine the differences, not just cultural, but legal, that they would have together. A second issue would be that each country in the BRI has a different deliberative capacity. And what that means is when they enter into these contracts, these very, very large contracts for infrastructure, not all states are ready to assess what's going to happen if there are delays or if there's a failure of a project. And then the third aspect of that, why ISDS is so important, is that each of these countries also has different rule of law standards. And that means that there's not always a lot of trust in domestic courts, especially when there's a lot of issues of corruption, which some of the other presenters have touched on today. And like Aaron has mentioned sort of about increasing labor rights and investment and development, China has to sort of project itself as a positive role model. There's so much discussion around the BRI being a way of China leading the world in development, in infrastructure and trade, and so it really has to set the tone. We've already heard a lot about the different sort of negative news that is coming out about things like Hambantota in Sri Lanka. In Vietnam, there were recently anti-China protests because they were concerned about investment and what that could mean in terms of long leases if there's failure of projects. And we also heard from individuals in Malaysia. Mahathir actually very specifically indicated that this issue is big because it could become a new version of colonialism if not watched, not watched carefully. So international investors in the BRI must be wondering, is China going to play fair? When we look at their courts, the answer is only going to be yes if we have a number of different and equally fair legal mechanisms that we can turn to. And Wei has done an excellent job of presenting those and analyzing those in her paper. And so we're going to look specifically at how ISDS can give investors confidence in these massive infrastructure projects and any kind of agreements they're going to create. Specifically from a practical perspective, I'm not going to recommend something to clients if I don't believe that the dispute resolution provisions are going to take effect. Or if the investors are going to get themselves into hot water, that they're not going to be able to make good on any of the things that they are investing in. ISDS, especially when it comes to Chinese investors, China should be taking the perspective that this will protect its own investors in a very big way, because as we've heard from other presenters, a lot of this is currency outflows, it's investment outflows from China, and it's very one-way development. So Chinese investors need to say, well, are we going to be protected? We need ISDS when we go into countries that have different traditions from us, and we need to be able to say with confidence, well, China's going to have our backs because they set the standard. So opening China to ISDS would be good because China doesn't have a lot to fear in this realm. I just want to say, it's not all bad. There's not a total lack of ISDS right now, or provisions or capacity, but it's that traditional issue of investors looking at it and not having a lot of trust because China doesn't have a lot of experience. These are new courts, new provisions, and how can we trust that China's going to do the right thing when it comes to these situations? It's only recently begun to allow broader recognition and enforcement of New York Convention awards, but it still has a commercial exception. And its experience with ICSID is very seriously limited. So Kun's going to explain a little bit more about the importance of the New York Convention and ICSID Convention.
Thank you, Jasmine. So as we are taking investor stake protection approach for Chinese investor, so now I'm turning to how China is implementing the two most important investor award enforcement arbitration agreement. One is the New York Convention and the other one is the ICSID Convention. So China acceded to the New York Convention in 1987 and the ICSID Convention in 1993. Like many other states, China made a commercial reservation for the New York Convention. However, right after China acceded to the New York Convention, the Supreme People's Court, the SPC, issued this notice saying, well, the commercial disputes are going to cover this kind of disputes, but not ISDS disputes. That was in 1987, at a time when there wasn't many ISDS disputes. And when China acceded to the ICSID Convention, according to the ICSID Convention, China submitted this notification saying that, okay, in the future the disputes under the Chinese treaties, we only agree to submit certain quantum dispute regarding the expropriation. That was in 1993. Why China took such an approach at that time? So first thing is, in the 1980s, China was still an capital importing country, and it was being very concerned about being sued in foreign courts or international tribunals. And also, China took this absolute immunity position, which China argued that, well, we cannot be sued in foreign courts, and vice versa, we will not have foreign governments to be sued or entertained in our courts. So, and also, when you look at the early Chinese bilateral investment treaties, including some ones with those BRI countries, we found that all of those treaties have only limited access for investors to international arbitral tribunals, which are the quantum disputes, as we mentioned. However, the scenario is different since the late of 1990s, when China started to have this Chinese corporations going abroad to invest, and it was at that time China started to sign investment agreements with a broad ISDS clause that basically was saying any investor from any of the treaty party can submit their dispute to international arbitral tribunals, including those ones under the auspices of the ICSID. So, however, because of this ISDS reservation by the Supreme People's Court and also this silence in China's implementation of the ICSID Convention, because unlike the New York Convention, the SPC didn't issue any guidance on the implementation of the ICSID Convention. So we started to wonder how should we, or how should China, or who should do this to better implement the two treaties. So we came up with the argument that the Supreme People's Court is best positioned to do this job, and I will have Jasmine to explain why it is so.
Thank you, Quinn. And I think it's one of those things where if you come from a state that has a strong legislative capacity, you're going to look at China and say, well, why don't they just make more laws? Why don't they step in? Why doesn't the government see that there's these issues? They've created this Belt and Road Initiative. Why haven't they said, well, we need to start to look at the legal implications? And it's because the National People's Congress is quite slow moving. And that's why, starting in the 1970s, the SPC, the Supreme People's Court, decided to start issuing guidance to lower courts to sort of help rule of law across China, and specifically to deal with situations that were novel or complex that the NPC had not already provided legislation on. Specifically, these interpretations, like most civil law countries, they're not binding, but they are authoritative, and they provide a lot of guidance to these courts without replacing the NPC's lawmaking authority. It's also, you can imagine with the BRI that there's a lot of new complex cases that are coming, and this interpretive guidance can provide a lot of flexibility. So in 2010, the Supreme People's Court decided to start issuing formal guided cases. And if anyone wants English translation of these cases and more analysis, the Stanford Law China Guided Cases Project is an excellent source for those. So the SPC has, generally when they release one of these guided cases, they've released two sets in particular about the Belt and Road. And these cases explain the facts of a case that has already occurred, and then it analyzes the reasoning of the case. Usually it's a case that the SPC has been involved in, providing the reasons. And then it explains a broader application for what you can take from that. So that lower courts will be able to apply these reasonings in complex BRI cases that begin to come up. One of the cases that we have focused on specifically in our paper is about the recognition and enforcement of New York Convention awards, and that's the Siemens, Shanghai, and Golden Landmark case, which, we put more detail about the actual facts and the analysis of that case in our paper, but suffice it to say the SPC said that enforcement of an arbitral award helped strengthen international credibility in China's dispute resolution mechanisms and would influence China's rule of law. This shows that the SPC is comfortable stepping into this realm and providing guidance on something as important as rule of law for the BRI. However, what we have missing still from its commentary is ISDS. And that's why I'll hand it back to Quinn to start with our recommendations about what the SPC should say.
Thanks, Jasmine. We came up with 3 recommendations for the SPC. So as we mentioned in her presentation, the SPC just established this CICC to counter international commercial disputes. As she mentioned in her presentation, something is missing. What is missing? The trade disputes, the investor-state dispute that involving sovereign states. Why ISDS disputes are not or were not supposed to be commercial disputes. So I think one of the concern from China probably should be that, because it involves a sovereign party, it involves the possibility that a sovereign could be sued in Chinese courts. We want to deal with those kind of things. We want to be friendly with all of our friends all across the world, especially from BRI countries. We don't want to use our court system to impose our kind of legal obligations to our country. But I think this is wrong, because first, China has an obligation under both treaties that it was obliged to recognize and enforce treaty awards. Second, if China doesn't play or comply with those treaties, then how investors will have confidence in this BRI system? So firstly, that we recommend that China should firstly repeal the commercial reservation in its 1987 notice of the New York Convention. And then it should issue a note specifically saying how ICSID award should be recognized in Chinese court. Probably it could say the new Chinese commercial court could be the designated authority to do such recognition as required by the ICSID Convention. And to do so, and to ease the Chinese authorities' concern on sovereign immunity issue, we came up with our second recommendation, which is, as China is asserting this absolute immunity position, so China in its guidance could say, well, because it is only the recognition of such kind of words, so it will not touch upon foreign sovereigns' immunity in Chinese courts. And then people would probably ask, well, if you're only recognizing a foreign word, what's the value of this award? The value is that once it is recognized in the Chinese court, it can be enforced in other more than 150 countries under both treaties. So that is the value of this recognition. And it puts China as one of the most compliant nations for those treaties. And later, our second recommendation, and later Jasmine will go further, deeper to explain why, when it comes to the execution of sovereign assets, the Supreme People's Court should not just issue guidance. It could wait. It could do the guiding cases when the real dispute comes up.
Yeah, so as Kun was saying, I think the SPC, because of its guiding cases system, is very well positioned to wait until a case comes up with recognition and enforcement and specifically execution to make sure that these awards can be made good on. Investors are not going to start to trust the system until they say, I've got an award in hand, I want a judgment, I want to be able to execute against assets and make sure my investment is going to be safe or that I can make good on it afterwards. This is a much more practical approach, and it allows investors to say, okay, well, the SPC will have our back if these cases arise. And again, it doesn't impinge on the legislative power of the NPC, and it doesn't touch on issues of immunity because parties have signed on to these conventions, and therefore, they're ready for execution of their awards should that come to happen. So, just as a concluding note, as you've heard from the various panelists, and as I'm sure you've considered over the course of this conference, China really does want to respect other countries' sovereignty, but if it's going to be continuing with the BRI and listening to the issues that it's had and trying to improve on those, it really needs to focus on having as many legal tools available as possible, and that includes ISDS. Now, we're not saying China should abandon mediation, negotiation, conciliation, and especially not the new commercial courts, but it needs to have ISDS at its disposal as well if it wants to be credible. And luckily, this somewhat niche topic has been highlighted by MOFCON recently. There was an announcement earlier this month that they're looking for input specifically on ISDS and on how best to have it work in Chinese courts. So China is also participating actively in UNCITRAL's Working Group 3 discussion of the new multilateral investment court. So China is taking this matter quite seriously, and I think wants to lead the way and have credibility, especially among the states that may not have trustworthy domestic or international courts at its disposal. We're willing to take China at its word that this is not just a new version of colonialism, as Mahathir may have said, and that it can really improve infrastructure development in these regions. If China genuinely wants to foster development, or as the saying goes, 要想富, 先修路, or if you want to get rich, build a road, then it should not shy away from ISDS and should demonstrate its readiness to enforce rule of law. Thank you.
Thank you very much. From this session, I think, if I may just give two guidance or thoughts, especially to the non-lawyers in the audience. One is that as lawyers, we learn from the start that we should always hope for the best and anticipate the worst. In other words, we always hope that you never go to litigation, and that when you contract with a third party, whether it's an undertaking, an individual, or a state, that everything will happen smoothly. But very often it does come to the worst. So you have to be prepared, and you have to have appropriate dispute settlement and a very clear understanding of the rights and obligations incumbent on each party. That's why it's so important to have those two last presentations. The first presentation went to the other very important line that we always have to keep in mind as lawyers, which is that the law is basically always a combination, a balancing trick. You see Lady Justitia with her balance, it's a balancing trick, basically between private and public rights. And very often when we talk about investments, we talk about private rights, but there is also the public interests that are at stake, which were reminded by the first presentation. So I'm sure that the combination in this panel has triggered quite a lot of questions and comments. We have started 20 minutes late, so I hope we still have 15 minutes, 10 to 15 minutes for questions.
15
Okay, so we open the floor for discussion. As in the other panels, if you can please state your questions or comments briefly, first present yourself and indicate to whom on the panel that you are addressing the question. Let's perhaps start row by row, so you don't have to run from one end to the other.
Yeah, thank you, Chair. Henry Gao from Singapore. My question is towards the last paper, a really interesting paper on using the court mechanism in China. Now, my question is, if you look at most of the BRI projects, the investors tend to be Chinese investors. So I wonder whether there's really a need to improve it to that the investors would use the Chinese court system. Because as Chinese investors, they are already have a preference to use the Chinese court system. And another related question is, how do you deal with the foreign governments? You propose that to make it easier basically to sue the foreign government in Chinese courts. I'm not sure whether the Chinese agreement would like such an approach, because the BRI, at least from the way the government put it, is more like building goodwill in all these neighboring countries. So if the Chinese government is not willing to pursue these cases, who would then the private firms be able to turn to when they have dispute? Thank you.
Okay, there was another question here, please.
Thank you, Suresh Nanwani. I have two questions, they're sub-questions. One is we also referred to on the Sri Lanka matter, the port. In that transaction, were there agreements? What were they? And how was, I know there was a problem, we all know there was a problem. Was there a dispute or reference or what happened? Basically, I'm asking, was there an agreement and what happened? The second one is a takeoff from what Henry has just mentioned. If we have Chinese entities that are state-owned, how does that affect immunity questions?
Thank you. On the second row, you also have a question there to the right.
Thank you. My name is John Howard, also from GIZ, the German Development Agency. I have a question for the two presenters on ISDS. I want to ask whether you see potential risk for countries along the Belt and Road in the context of ISDS. I mean, especially in Brussels, the discussions about the need to reform ISDS is pretty well known. The investment for system in Canada had agreed to it in the CETA context. So whether you see a risk in terms of conflicts of interest, lack of transparency in these proceedings, also on the substantive side, whether it would make sense to, you heard in the case of the Kenya railway investment, contracts where we don't know the provisions and the content, whether we want to give additional enforcement mechanisms to investors for these intransparent, sometimes, maybe disadvantageous contracts. Thank you.
Yes, just behind you.
Elena Tracy, Rachel Carson Center for Environment and Society, Lübeck Maximilian University Munich. A question to Aaron. As far as I know, in the last few years, Chinese government produced a number of voluntary guidelines for environmental and social standards. Some of them were sector-specific, like forestry and mining industries, and some were more general. And among general ones are those that prescribe Chinese foreign direct investments to follow the domestic standards in the countries that they're investing in, like labor, including labor standards. So in your experience in Saipan, and also you mentioned our country here, it looks like they didn't follow those guidelines. So under what conditions do you think it's possible that Chinese companies will actually follow those voluntary guidelines introduced by the government of China? Thank you.
Thank you. Who else? Well, let's continue on the left and then come back on the right. Okay, yes.
My name is Aram from Yangtze University Rotterdam. I will try to speak as clearly as possible this time. I have two questions, and first the question goes to Aaron, because I was quite shocked by the Saipan case, but I'm also quite confused because I didn't really see how the judicial powers of Saipan plays in this case. Because according to my knowledge, if you make an investment, that investment should also be legal and be established according with the law of the host state. But actually, I didn't really see how Saipan, the domestic cause of any judicial powers works in this case. So, and the second, my questions get to the two speakers on the SDIs. And my question is, do you have any ideas about is there any state that published any law or guidelines on how to enforce the ISDS claims, like from other jurisdictions? And also, I'm quite stuck about your three recommendations for the Supreme Court. Firstly, I was not, because you didn't really mention the ad hoc arbitrations. Secondly, because, let me check one thing. Secondly is the third approach you recommend is the Supreme Court should ensure the state to not use the immunity to enforce the arbitration. But I'm thinking because if China agrees with the ISDS, I don't think it's a good idea if after the judgment and they say that, okay, I don't want to enforce that because I have immunity. So I think the general thing is we don't need to consider about the immunity in that specific issues. And also, I was not quite sure about how the Supreme Court ensure the government to not do something according to Chinese tradition. Thanks.
Thank you. Mr. with the white shirt.
My name is Wei. I'm from KU Leuven, a law student of KU Leuven. I have two questions for Dr. Aaron. I'm very curious about the Saipan Island cases because I have heard it before. My question is only a labor law dispute or the Chinese government gets involved, like the enterprises get the acquiescences from the Chinese government? And how do you anticipate the Chinese government cooperation on such issues? Another question is about the migrants, the babies. In Saipan Island, as you told us, it's a Commonwealth of United Nations. There are many Chinese women going abroad and deliver the American babies in Saipan Island. According to what I know, there's nothing illegal as long as they can pay the funds for the medical procedures. Do you think will the United Nations, the federal government, take some measures to control such issues? Thank you.
Thank you. Other questions from the other side? We're going to take just one round. So one more question, two more questions, and then the brief replies if possible. Good.
Thank you. My name is Huar. I'm from China. I'm not asking a question. My comments go to Dr. Arden also. So I just want to make some complementary points to your presentation based on my experience in 6 countries in Africa.
Can you keep it brief though?
Yeah. So just to clarify, I'm not working with a Chinese company. I was working with the UN Refugee Agency, but I have been living with my friends who work with Chinese companies in different countries of Africa. So I understand what conditions they are living there, and also the regulations and the agreements between China and these countries. One example is in Ethiopia. One worker going to Ethiopia from China, the company has to employ at least 13 local workers. And another example, the workers, either local or Chinese or from China, so every week they have 1 day and a half for rest. And then they even have Chinese chef because they want to have Chinese food. That's why I usually went to the companies to have some Chinese food. So this is another story very different from yours. But I want to say thank you for bringing this case to us. It allows us to see a real story and a story of human rights abuses. Thank you.
Thank you. If I understand correctly, you're saying there are other stories to tell which are positive and not this negative one.
My question also to Aaron from New York University. My name is Peng, and I'm from University of Bern and connect to research there. So my question is, because today's topic is BRI, so my question is, do you think BRI is benefit to the improvement of the local standard, or will it make it worse? Yeah, thank you, and why?
Thank you for those questions. We will start in reverse order. So, if you first
apologize, it's hard to write down all the questions that we got. So we'll see if we, between the two of us, are able to cover them all. To answer Professor Gao's question, I think I think you were asking about improvements to the Chinese court system when there's already sort of a predisposition for Chinese investors to go there. And the issue is more that all the parties in the BRI need to be sure that they're going to be heard by an impartial, unbiased court system. And colleagues of mine at my firm in Hong Kong and Singapore both say that individuals from other countries who are non-Chinese companies who want to bring suits are concerned about Chinese courts and their potential bias or lack of impartiality. And so arbitration is really the best way of dealing with these disputes and of ensuring that panels, as they're chosen, whether ad hoc or through other international rules that are put into the contracts, that you have something that's more equitable and more likely, or it's seen by investors at least, to be more likely to produce a fair result. If China wants to continue engendering better investment and more protections, it has to show and lead the way with rule of law and show that its courts and its arbitral tribunals are not going to be subject to bias and have these issues. And I think that sort of also leads into the issue you said about why the Chinese government is not espousing cases, and that's particularly the reason why we have ISDS in the first place, is because of the long tradition of governments having to take on investors' cases and issues around immunity, and the whole idea is that investors should be able to deal with states themselves in these kinds of situations. I think the second question was about Sri Lanka and about what happened in the agreements. I'm not entirely sure about what kind of dispute resolution provisions they had, but it seems as though in the situation of default, that's how they ended up with a 99-year lease on the port. And so I don't know that, this may be a great example of how China has said to itself, or to the partners that it's working with, yes, we'll invest with you, and we won't worry about litigation. We're not going to sue you. You'll just have to, hand over rights to us, which, as we've heard from many other presenters today, is highly problematic. And that's why we think that having more ISDS provisions and more ability for investors and states to engage in, just to start the process with mediation and arbitration and to be able to get down to these issues, we need all the tools available to address these things.
Thank you, Jackson. I will address the second question about the SOE's immunity and also about China's approach to ISDS and also other ad hoc arbitrations and immunity. So turning to the Chinese SOE's immunity, I think, firstly, there are cases that Chinese SOEs are claiming immunity, so for example, in the US courts. And in one case, under the US national legislation, the Chinese SOEs was given immunity in that case, being treated as the arms of the Chinese government. I think whether Chinese SOEs can be considered as part of the state is more about the national law where Chinese SOEs are being sued. The Chinese government position is that SOEs are not part of the state and they cannot claim immunity. But I think the SOEs are taking different litigation strategies, so we have to observe it on a case-by-case note. Regarding China's approach to ISDS, I think, going back to CETA, CETA now is provisionally enforced. And the part that is not enforced is the investment court. And now this is being debated in the UNCITRAL and also UNCTAD. And I think China is carefully observing it and is taking a very pragmatic approach. Is, well, we wouldn't say what we like or we don't like, but we will see how it is going. And that's why MOFCOM is soliciting public opinions from the Chinese community. And I think that in a conversation with one of the Canadian scholars, she was arguing boldly that China might embrace this investment court idea. Why? Because China has this massive experience now in WTO and was being more comfortable in the litigation. China might be being comfortable in this appeal mechanism in like investment court, and also China might get a chance to nominate a judge instead of having other the parties nominate one of the arbitrators. And on ad hoc and immunity, China, well, in our paper we addressed this issue. For our ad hoc arbitration, if the award comes to China, it will be governed by the New York Convention. And when it comes to the immunity, I think that's why we argue in our paper, when it comes to recognition, it is only transferring the award into an enforceable judgment. It wouldn't touch upon the substance of the sovereign's immunity. So we argue it won't affect China's immunity position. Thank you.
So I just wanted to add one thing. I do realize that I didn't address the issue about CETA very specifically, but I know there's been issues or discussion in the European Union after the Ashman decision earlier this year. And I think we have yet to see what the fallout of that's going to be. But I would say for the last few years, among developed countries or higher income countries, that there is sort of a distaste now for ISDS. And that anyone who's sitting here needs to think about how important that can be for countries that don't have adequate standards for rule of law or issues of corruption. Higher income countries don't have those same issues to the same degree anymore. And that's why when we see developments and discussions in Europe about do we need these provisions, especially within the European Union, we shouldn't have bilateral investment treaties with ISDS anymore, we don't need it. We have our own courts. That's fine, but this discussion, it really does matter still for BRI countries because there are so many countries. If you think about Cambodia and there's so many countries that have very fragile legal systems and very fragile economies that would really benefit from mechanisms outside of them and just being able to follow rules. And China needs to sort of set the tone when it comes to that. Thank you.
Why you want to say something briefly or no?
Okay, I've been invited to keep it very brief, but I'm happy to talk further at the coffee break. So just to try to respond, not one by one, but a few quick general points. Thank you for your comment. I do appreciate, I think it's hard and maybe even foolish to try to generalize too much about the Belt and Road because I don't think anyone in this room can really define it with any accuracy, and so to try to make generalizations about it would be tricky. Obviously, there's a lot of diversity. So the question for me is, well, what explains some of this diversity? And in terms of enforcing labor rights or environmental rights, I think, for me, what's obvious is, it doesn't matter what's in the contract, it doesn't matter what the laws on the books necessarily say, it doesn't matter what's in a Chinese government guidance document. What matters is, can you enforce it? How real is it, the threat that there's going to be penalties for non-compliance? And so in the Saipan case, the local government wasn't very effective, right? They were actually bending over backwards to accommodate the Chinese project. What happened to play out in this case was that the federal authorities, the FBI, the US Department of Labor, did take some action. But I wouldn't celebrate it too much. I think why this case is sort of interesting is it's the United States. These are federal legal enforcement authorities. We often talk about these things happening in countries where there's a weaker rule of law. But all of this stuff transpired for a year before the federal authorities took any action, right? So even in countries where you have the strong laws on the books and enforcement authorities, this still happens. So what could matter? What can make a difference? I think one, maybe the Chinese government could be more forceful. In this case, I've heard that the consulate was involved and maybe put some pressure on these Chinese companies to resolve what happened after the media got involved. I think these Chinese companies look to do projects in other countries and internationally, and so want to have a good reputation and maybe don't want to be seen as, violators of labor law or human traffickers, and so that might have some currency. And I think in the United States, what we're trying to do is think of domestic laws that punish or hold liable U.S. companies for what they do abroad. Right? So if they're involved in trafficking, if they're involved in other types of violations, what can we do under domestic law that is enforceable, that has penalties, in order to try to change that behavior? And I'll talk to you about birth tourism later. But I think the only short point on that is right now the United States is reconsidering this whole idea that Chinese can come to Saipan visa-free, in part because of this, in part because of birth tourism. So these things have larger implications on China's general soft power.
Thank you. As a very last word, I would just like to thank our panelists very much for these very interesting talks and extend the invitation, which was already launched, to continue the discussions over coffee. Thanks a lot.
Is it really necessary? Excuse me, sir. So when you send like the slides to the participants, I will have to ask that. Are we sending slides to the participants? Oh, do it?
I'm not sure, but I think we can check that. I'm not sure.
Maybe after the conference, I can.
Yeah, we can do something like that.
Okay. Yeah.
But you will have. It's better you contact either Adele, you know Adele, or Adele.
Confirm with her
yes.
again.
Yes.
Okay. After conference, you will be here.
I will not.
And after conference, you will like wait 1 second.
Ah, sure. I can wait. Yeah.
Thank you.
No worries.
Als we hier hebben, moeten we misschien eentje maken.
Right, so we need to
Dat moet toch wel, ja, er zijn er wel.
Might be better to get that.
Dus niet gevonden?
Nee.
Ik zal eens kijken misschien. Even zoeken misschien. Wat zijn dat die kaartjes gemaakt zijn? Moeten we dat imposeren kunnen of is dat imposeren?
Recommend from my RD handwriting.
No, I don't have
Yeah, yours is much better. Is it my writing? Really hard.
Unless you want to do
Oh, yeah.
But it's better than like coffee. Might be very essential. I think it's I'll give you that. Yeah, but I don't find people are surprising. Yeah, sadly, the last
Die wij dan ook een beetje breed uit. Die wij ook misschien in stippen. Maar yes.
I already need to know where I brought it.
Okay, so welcome back everybody. This is the last panel and we're all very tired but exciting papers nevertheless. And so I'm going to briefly introduce the speakers, the four speakers for this panel. Dr. Astrid Scala-Kuhlmann, who's special advisor for the German Development Agency, and in particular she focuses on the Belt and Road Initiative and the strategic issues with China and G20 and global partnership issues. Then we have Dr. Fabio Indeo, who is a non-resident research fellow at the Energy and Governance Security Korea and NATO Defense College Foundation. And he researches on geopolitics in Central Asia. Then we have Ms. Yuja Wei, who's PhD candidate at the University of Wisconsin Law School, and she does research on international organization, global governance, and WTO. And then lastly we have Mr. Tekir, who's PhD candidate at the Middle East Technical University in Turkey, and he does research on geopolitics and Central Asia and the influence of Russia. So I will give the floor to Dr. Scala-Kuhlmann. Sorry for mispronouncing your name.
Good afternoon, ladies and gentlemen. Thank you very much to your center, to the organizers for the invitation, and in particular for placing me at this prominent time, because I think it's really favorable to speak in the afternoon of such a conference. Firstly, you get a really informed audience at the time of the day, and second, you only get the really committed people, because all the others have already taken off for the weekend. So, BRI and sustainability is actually something GSZ, that's the organization I do represent here, has been looking into since almost 2 years. Why is that so? GSZ is the German government federal-owned organization. It's a federal enterprise for development cooperation and international cooperation. And we do have, mostly commissioned by the German government, we do have portfolios in almost all BRI countries, including China. So I think it goes without saying that we have an interest, and we had started to have an interest. What is the BRI doing in these countries? We do development cooperation projects on behalf of the German government, and also how can we and should we support and how can we get engaged with our Chinese partners, maybe to influence the BRI to align with sustainability, in particular with the Agenda 2030. So I'm very pleased that I can kick off the session here, and I will have the pleasure to precisely talk about the linking the BRI and the 2030 agenda. The sustainability and 2030 agenda has been mentioned a few times today, but nobody really had looked deeper into that. So I don't think I will double too much what had been said before. It was actually already shortly after the launch of the SDGs, as you all know, in September 2015, when international organizations and academia, think tanks began to discuss the linking between BRI and SDGs. Of course, this is easy to explain. It's a necessity to align these two frameworks, if I may say so, because of the enormous scale and scope of the BRI. Infrastructure connectivity being, so to speak, the center of gravity of the BRI, has an interrelation with many SDGs, in particular with SDG 9, which is aiming at building resilience, disaster-resilient infrastructure, So this was identified soon, but also other SDGs such as SDG 8, promoting economic growth, and others. So it was looked into the interrelationship, and some academics thought there could be a mutually supportive interrelationship between the two. However, if not done properly, and this we have heard several times, the BRI implementation could also be counterproductive to the 2030 agenda. For example, if you think of the environmental and climate footprint of the BRI. It's also worth mentioning that the SDGs do emphasis on new global partnerships in SDG 13 or 17 anyway. So BRI could very well also be a supportive instrument for the implementation of this SDG. So to better understand the correlation between the BRI and the 2030 agenda and how to move the BRI cooperation and implementation into a more inclusive and sustainable direction, I believe we firstly have to better understand, and it's worthwhile to look for a moment, how cooperation and implementation mechanisms of the BRI work. Because we have heard, I think, and was also my impression again, listening to some of the speakers, that there's often a lot of misconceptions, and sometimes it's not so clear who is really the implementer and how the cooperation structure is set up. So we know, and this has been said, there is no overarching domestic nor international framework for BRI. I always phrase it like there is no phone number to ring in Beijing if you want to really get engaged in the BRI. However, there are, as you all know, there is the NDRC leading group, and there are many other ministries which are involved in the BRI at the national political level, but there is no single institution. It's rather a highly complex, I would say multi-country, multi-regional and global multi-stakeholder initiative, and as we have heard before, it's rather composed as a process. However, initiated and still to a large extent dominated by Chinese actors. So, if you look a little bit closer, and we want to understand the cooperation and implementation structure, we can look into the BRI concept of 2015, which also has been mentioned today. This concept has been issued by the NDRC and State Council, and it sets out different cooperation mechanisms. In particular, three mechanisms or three levels are mentioned. Firstly, bilateral cooperation. Second, multilateral cooperation. And third is a mix of international fora, exhibitions, and other activities. So since 2013, actually the BRI has birthday next week. And amazing enough, it seems to be a little bit fake for me. It's my birthday. It's the 7th of September 2013 when the BRI was launched in Astana, as we heard before. So since that launch, there was a magnitude of cooperation and implementation activities which had taken place. In particular, in China, there are more than a dozen think tank alliances by now, associations, research centers of the State Council, Silk Road think tank associations, and many others, many conferences, and I believe several of you have participated in those events. There are by now also numerous BRI research institutes and projects at Chinese universities, but also we see this also taking place in other countries, because just recently I learned there's a BRI research center in Prague, and Warsaw is working on that. Of course, the majority of these research institutes are based in China. It's also worth mentioning the regional cooperation and implementation structure. Throughout the last couple of years, several regional organizations have teamed up with the BRI, with China, and have set up agreements on the cooperation for the BRI. So I already got the notion that I only have 5 more minutes. I think I've been cut down to 10. Is this correct?
No.
No? Okay, good. Anyway, so I try to speed up. If we try to categorize these different types and levels of BRI cooperation and implementation structure, we can categorize 3. There is a unilateral one, where normally China is designing the strategy and is controlling the initiative or the organization, for example, the Silk Road Fund, and it's fully under Chinese leadership. The second is the bilateral, which has also 2 levels, is the government level, all these memoranda of understanding which have been concluded between the leaders of different countries present last year at the Belt and Road Forum in Beijing and the Chinese government. And the third one, which may be the most interesting one for sustainability, is the plurilateral and multilateral category. So let's look more concretely, I guess I have 3 more minutes, into the different forms of cooperation and implementation from a sustainability perspective. There is, of course, the business sector, because ultimately the BRI is taking place at the local level with investors, with enterprises, and if they do not embark, and if they do not include environmental and social standards, it will be very hard to have a sustainable implementation of BRI. Since I'm a little bit under time pressure, I will only embark now on my second pillar, trilateral cooperation for sustainable business solutions, because I can tell you about a very concrete project GIZ is undertaking together with Chinese industry associations. It was actually one of the questions in the earlier panel which related to that. The German government commissioned GIZ to team up with the Chinese chemical, mineral, blah blah blah, it's a very long word, association, to develop guidelines for the outbound investment of the Chinese mining industry. So responsible leadership is set out in these guidelines, and we are doing the same thing with CINCA, which is the China International Contractors Associations. So all the Chinese businesses which do the infrastructure projects are under this association. So again, here we have the guidelines for the outbound investment, which are strongly related to environmental and social standards of international standard. Last but not least, I would like to mention the international financial institutions. There have been already a lot of talk today. Who is financing AIIB and NDB was mentioned, and I think there are really good news when it comes to these multinational development banks and these institutions, because they do apply international, let's say, quality standards, green policies, and do this way ensure that SDGs are implemented in the BRI on the ground. Very last but not least, let me mention a few agreements and programs, cooperative programs between China and the UN family. It's really amazing, and it's not so well known to many people involved in the BRI, but meanwhile there are 23 UN organizations, UNEP, UNIDO, UNICEF, WHO, which have joined BRI cooperation programs. So there is, for example, the UNEP Green Belt and Road Strategy, together with the Chinese Ministry for Environment Cooperation, and there are other interesting green, so-called greening the Belt and Road initiatives, very active WWF. I've met two prominent representatives from these institutions, which have decided we are not going to stand out and argue and criticize the BRI, but we're going to get engaged and make it a more sustainable initiative. So this is now really my very last slide. This is my recommendation in a nutshell. I personally believe also the European decision makers should get engaged much more in the BRI cooperation and implementation, because this is the only chance to make sure that environmental and social standards of international quality will be applied, and therefore the BRI will be used and could be used as a vital enabler for the 2030 agenda. Thank you very much.
Good afternoon, everyone. It's a great pleasure for me to be here, and I'd like to thank you, the organizers, first of all, Maria Dele Carrai, to give me the opportunity to present my research. So, my presentation is focused on Central Asia, and we analyze how the Belt and Road Initiative could influence foreign policy orientation of Central Asian Republic, their economic evolution, security issues, and this enhanced cooperation between China and Central Asian republics is currently modifying the regional geopolitical balance, because this strategic partnership represents a clear challenge to the Russian traditional role in the region. At present, China is the main economic partner in the region. Since 2009, Russia lost its semi-monopoly on Central Asian oil and gas exports, and also in the security field, where Russia is the traditional security provider for Central Asian countries. Now the strategic relevance of this geo-economic corridor is pushing China to increase its not military presence, but its will to provide security in the region. So, if we analyze two of the main aims of the Belt and Road Initiative, we can understand how Central Asia is strategic, the geographic and the strategic centrality of Central Asia. First of all, one of the main targets of the Belt and Road Initiative is to develop overland or continental corridor in order to reduce the dependence on maritime export routes, a kind of strategy of diversification. And we clearly understand that Central Asia is crossed by two of the 6 economic corridors. The first one, the new Eurasian land bridge, starting from China and crossing Kazakhstan and Russia before to reach Europe. And the second one, the China, Central Asia, West Asia economic corridor, which is most important because does not cross Russia, and starting from China, crossing Uzbekistan, Turkmenistan, and Iran, is a kind of alternative corridor for China, because this corridor does not cross Russia, of course, and now in 2016, but also in 2017, the new Eurasian land bridge accounts for 68% of total Chinese export to the European Union. So it's very, very important. The second point, the creation of a buffer zone in order to maintain regional stability and security. Because Xinjiang, the western province of China, is a strategic energy and economic hub, a BRI gateway. And 3 of Central Asian countries, Kazakhstan, Kyrgyzstan, and Tajikistan, share a border with Xinjiang. And Turkmenistan, Afghanistan, and Tajikistan share a border with Afghanistan, where China invested billions of dollars in order to develop the INAC the INAC copper mine. And this slide, in my opinion, is very important because we can observe that the China Central Asia West Asia corridor is composed by different branches, but which highlight the existence of a multimodal or an intermodal architecture of transport. So, exploiting the Caspian ports as Aktau and Kurik in Kazakhstan and Turkmenbashi port in Turkmenistan, China has the possibility to use the Caspian corridor in order to reach the European Union, and the realization of additional infrastructural projects such as the Baku-Tbilisi cars or the Lapis Lazuli corridor or the Turkmenistan, Afghanistan, Tajikistan corridor, or first of all, the Navoy from Uzbekistan to Turkmenbashi port will allow China to develop, to exploit an alternative corridor. Currently, the corridors from the Sino-Kazakh border to Aktau, the Caspian port in the Kazakh shore of the Caspian Sea, is the current existing railway connection, and the other project will become a kind of subsection of the Belt and Road Initiative. So it's important to develop and to promote the regional cooperation. We can observe that there is a kind of strategic convergence of interest between China and Central Asia. These are some of the main strategic and economic gains for Central Asian countries becoming part of, being part of the Belt and Road Initiative. For instance, the transit fees, of course, but also the inclusive dimension, as in the case of the China Central Asia gas pipeline, which after the realization of the line D, all Central Asian countries will be included in this kind of regional energy cooperation. Some countries as suppliers, some other countries as transit countries. And the inclusive dimension is clashing with the Russian project of the Eurasian Economic Union, because this is initiative, and there is not a rigid membership becoming part of this project. So this is the main difference which push Central Asian countries to privilege the Belt and Road Initiative. In geopolitical terms, Belt and Road Initiative allows Central Asian countries to develop a multi-vector foreign policy balancing Russian interest in the region. We can observe that after 2014, the combination between the low oil prices and Western sanctions hamper Russian attempts to invest in the region. So China is currently the main investor in the region, and Russia is not able to fulfill its obligation and promises of investment in the region. And in Kazakhstan, President Nazarbayev highlighted the convergence between the Belt and Road Initiative and the Nurly Zone economic strategy, or Bright Road, because both strategies are focused on the realization of infrastructure projects. And the new proactive approach of Uzbekistan with the new president in order to improve regional cooperation is a key component, a key dimension within the Belt and Road Initiative, because promoting regional cooperation allows to realize infrastructural projects. For instance, the railway between Kyrgyzstan and Uzbekistan, which will be linked to the railway from China and from Uzbekistan to Afghanistan or Turkmenistan in order to reach the Caspian Sea. This kind of sub-segment or sub-infrastructural segment which will implement and complete this Belt and Road project. About the energy dimension of the Belt and Road Initiative. This is particularly significant because it's as we can observe, there is a big difference in the Belt and Road Initiative if we speak about the energy dimension. The Central Asian countries has become strategic partner in the energy field for different reasons. First of all, the dependence on energy imports for China and the high dependence on maritime energy routes. So China needs to diversify the import routes, and one of the main key elements of the foreign energy policy of China is to realize overland pipelines in order to bypass Malacca choke points. Currently, 75% of Chinese oil imports daily cross Malacca. Malacca is daily crossed by 18.5 million barrels of oil, which also Japan, South Korea. So it will be interesting to develop a kind of discussion about the need to ensure the security of sea lines of communication, because all countries, all India, South Korea, Japan are also concerned about the security of the sea lines of communication in order to have the security of supply, in order to ensure their energy security, which is based on to have regular supply without disruption. So, Central Asian countries has become partner in this energy cooperation for China, and it is interesting to see that there is a kind of reverse energy corridor. So, the Belt and Road Initiative is the geo-economic corridor from east to the west. This component, which is a key component in the Belt and Road Initiative, follow a reverse corridor from west to the east, from Caspian to China. It's interesting, and in this reverse energy corridor, allow also Central Asian countries to achieve the diversification of their export routes, because China is a big China supports a big demand of oil and gas. And strategic energy partnership with its oil and gas supplier. Kazakhstan owns the 12th world largest oil reserves in the world, and Turkmenistan the 4th largest natural gas reserves in the world. The inclusive dimension of the Central Asian gas pipeline, and it is interesting to observe that all these projects were realized before the launch of the Belt and Road Initiative. But this project now has been included in the Belt and Road Initiative, especially for their expansion. The realization of a Line C in 2015 and the Line D made in 2020, made in 2021, and also to increase oil imports from Kazakhstan. These projects are under the umbrella or the BRI label. Turkmenistan covers nearly 50% of Chinese gas imports. Concerning the regional security, there is a few time. It's important to highlight that it is necessary to provide security for this geo-economic corridor, and China has a concept of the security dimension and the economic growth. Promoting the economic growth of Central Asian countries will allow to develop a kind of prosperity belt, a kind of economic growth belt, which preserves security and stability in the region. Russia was the traditional security provider in the region according to the division of labor. China was mainly engaged to promote economic cooperation, but now the permanent condition of instability in Afghanistan is pushing China to develop new security blocks, such as the quadrilateral cooperation and coordination mechanism, which include Afghanistan, Tajikistan, and Pakistan, excluding Russia. In conclusion, of course, BRI is an attractive idea to promote regional cooperation, and of course, there is not an homogeneous process, because Kazakhstan and Uzbekistan can profitably develop a multi-vector strategy in foreign policy, but other countries, the so-called weak pawns in geopolitical terms, Kyrgyzstan and Tajikistan, are not able to balance this Chinese initiative in the region. And as Professor Quick highlights in the first panel, there are a lot of regional hindrances in terms of the overdependence, in terms of the debt trap, which could hinder or hamper the realization of the Belt and Road Initiative. My really last point is the cooperation between China and Russia. Russia is, of course, interested in the Belt and Road Initiative, but we can also observe that Russia and China achieve different clashing interests in the region. In 2015, China and Russia agreed to synchronize the Eurasian Economic Union and the Belt and Road Initiative in order to develop a kind of cooperation. But we should also observe that the Eurasian Economic Union has been conceived as a challenge to the idea of China to realize a free trade economic bloc in the region. Because the Eurasian Economic Union includes 2 of the 3 countries which share a border with China, Kazakhstan and Kyrgyzstan. In the future relation of Tajikistan means that the new border between China and Central Asia will be the border between China and Eurasian Economic Union. So, in the medium term, I believe that there will be a kind of competition, even if now China and Russia cooperate in order to develop this project. I'm available to develop other elements of the conclusion, and I thank you for your attention.
It's my great honor to present my article here. So my presentation will illustrate from an environmental point what China is doing in response to international criticism that previous commentators have mentioned. I will leave for the audience to form your own opinions on the disparity between what China's policy and what is happening on the ground. So, in my view, China's BR initiative signaled a shift in China's foreign investment trend from the initial laissez-faire explorations by individual enterprises to a state-guided globalization of Chinese enterprises with an emphasis on sustainable development. Before embarking on the BR initiative, China has drawn attention to itself by Chinese enterprises' lack of regard for the environment and local communities in investments abroad. Since China declared its going-out strategy in the 1990s, Africa, Southeast Asia, and Latin America have witnessed a surge of Chinese investment. Yet accompanying rapidly increasing outbound investment is international censure for the negative impact of the investment projects on local communities, labor relations, and environment. The Green BR initiative stands as a conscious response to Chinese enterprises' irresponsible environmental practices during the past decade. Surprisingly, ad hoc approval of projects is not used by China as a significant tool to discipline Chinese investments. Instead, China's primary tools consist of governance by education and governance by disclosure. Governance by education involves prescribing how-to instructions for Chinese enterprises to deal with environmental requirements of the host countries. And governance by disclosure encompasses intensified reporting obligations on Chinese enterprises, government inspections, and whistleblowing. Regarding governance by education, a case in point is the annual guide on foreign investment and cooperation by country and region, published by China's Ministry of Commerce, a massive encyclopedia comprising the host country's ecological, political, social, and economic situations and legal requirements pertaining to foreign investment. In 2017 edition of the guide, under the section of how to establish harmonious relations with destination country, there is a specific subsection regarding how to protect the environment of the destination country. The investment guide is a compilation of individual country reports drafted by Chinese embassies. Though the advice given by Chinese embassies varies from country to country, the guide overall focuses on obeying local environmental laws and standards. As most countries now boast sophisticated environmental agreements and other environmental cooperative mechanisms, stressing on compliance with local environmental laws is not a reason to the bottom or an irresponsible advantage taking of low environmental standards in developing countries. In the Asia and Pacific region, governments indeed often outsource environmental policy studies and formation to international organizations. On the other hand, in a relatively short period of 5 years since 2014, China has considerably ramped up regulations of Chinese overseas investments. Through legalization and institutionalization of administration methods, China has established a strict oversight system of Chinese outbound investment, at least on paper. In this oversight system, China mainly relies on three mechanisms to enforce environmental protection in Chinese foreign investments: ad hoc approval, extensive reporting obligations, and follow-up inspection. According to administrative measures for enterprises' overseas investment that took effect in March 2018, projects that involve sensitive countries or regions or sensitive industries need ad hoc approval from the National Development and Reform Commission. Contrary to the common perception, in practice, only some 1% of Chinese outbound investments are subject to specific approvals. The second layer of control is exercised by imposing extensive reporting obligations on enterprises. Most Chinese outbound investments, about 99%, do not involve sensitive countries or industries and just need to make a filing online before investing abroad. After the initial filing, however, enterprises are obliged to keep the authorities updated on their investment projects. Follow-up inspection, the third layer of control, allows the authorities to sample registered projects for inspection and to demand information on investment activities from enterprises. The administrative measures authorize the NDRC, the National Development and Reform Commission, and its provincial branches to suspend or terminate projects if investors conduct unfair competition or disturb overseas markets or threaten or harm China's national interests or security. Whether disturbing overseas markets, national interests, and national security would encompass environmental issues with further clarification. These instruments, however, would be susceptible to fraudulent maneuvering in practice. The practical difficulties in conducting environmental inspections in an extraterritorial manner raise doubts about the effectiveness of this oversight system in preempting environmental breach by Chinese enterprises. In the push for the Green Beer Initiative, China broadened its focus, linking its trade and economic interests with its domestic and international campaign against the ecological degradation. China's Green Beer Initiative provides a complement to the United Nations headed multilateral intergovernmental model of international environmental governance. Coinciding with the trend of global governance without world government, China's Green Beer Initiative represents a soft unilateral approach to bridging the information, knowledge, and compliance and financial gaps that have threatened the effectiveness of the UN-headed environmental governance. China's Green Beer Initiative does not contest the principles, norms, or rules of the prevailing environmental governance regime with an alternative vision. Rather, it shares the principles and norms of the UN regime, reflected as the 2030 Sustainable Development Goals and international agreements such as the Paris Agreement, as its own principles and laws. China has built a good rapport with environmental international organizations, IOs, through engaging them in both its international and domestic efforts against ecological degradation. For example, in 2012, the UN Environment Program, UNEP, and China's Ministry of Environmental Protection signed a framework agreement on strategic cooperation, and since then China has pledged $2 million annually to the China Trust Fund and the UNEP to help build the capacity of developing countries in addressing environmental challenges. The most salient example of China's internalization of ILO's principles and norms is that the 2030 Sustainable Development Goals was invoked as the overarching objective of the Green Beer Initiative. Further, China's regulation of the ILOs is not only manifested in extensive incorporation of ILO's policy advice and norms into its plans and directives, but also the adoption of the ways in which ILOs work with developing countries in facilitating transformation of beer countries into green economies, a prominent role that ILOs have played in international environmental governance. In reducing information gap faced by many developing countries, China so far has focused on establishing information and communication technology, ICT-based infrastructures and institutions, including the big data platform, Green Technology Bank, and and the Shenzhen Environmental Technology Exchange and Transfer Center. These ICT-based projects would narrow the gap between the ecological needs of the BRIC countries and environmental technology, and thus reduce transaction costs in the environmental sector. The Big Data platform aims to be an open-access gateway for comprehensive information on the ecological conditions and environmental policies, laws, standards, technology, and industry of China and countries along the BR. To date, this platform has not been released, but some relevant research and reports are underway. Second, China is developing a green technology bank, but a technology exchange that intends to collect the suppliers and customers of green tech and to facilitate green tech deployment and transfer. China's third flagship project is the Belt and Road Environmental Technology Exchange and Transfer Center located in Shenzhen, China. The center is expected to involve in all stages of the innovation chain for environmental technology and serve as a key institution to carry out exchange and training activities with other developing countries. China's strengthened institution building for environmental technology transfer is facilitated by two facts. One, that the basic technologies in energy and transportation sectors have long been off patent. Another, China's innovation ability has grown fast. China's BR initiative has been criticized for raising debt risks in weak economies such as Pakistan, Malaysia, Myanmar, and Nepal. It is cautioned that the debt problem of the BR project runs the risk of derailing the initiative and even jeopardizing China's own economy. In addition, the proliferation of environmental technology and products is often hindered by market failures. These difficulties raise the question whether China will be financially sustainable to fulfill its environmental pledges. Recently, the UN-headed campaign for climate change mitigation and adaptation has experienced setbacks because member countries could not reach a consensus on the replenishment of the Green Climate Fund, the flagship fund of the UN Framework Convention on Climate Change. Yet, I argue the financial risks of some BR projects are unlikely to derail the environmental component of the BR initiative. The ICT-based green platforms that China has been constructing can draw their main users from China's domestic market and stronger economies along BR, therefore being less vulnerable to a debt crisis. Further, the cost of these platforms is relatively low compared with that of transportation or energy projects. The real concern that looms large on China's green BR agenda may be the effectiveness of China's actual territorial control of Chinese investments overseas. In fact, their recklessness toward the environment or local communities is the primary source of international criticism rather than insufficient funds. As noted, only about 1% of China's outbound investments are subject to mandatory approvals by authorities. For the remaining 99% of investments, China provides for intensified reporting obligations and government inspection as major means to discipline Chinese enterprises. Companies like this may manipulate or falsify reports of their investment activities. This fraud risk is more acute when the activities occur abroad, and the mechanisms to protect whistleblowers are weak in China. It remains to be seen how the Chinese authorities would carry out verification of the self-reports by enterprises and maintain sustainable capacity and motivation to monitor Chinese enterprises' activities abroad. Thank you.
Thank you for staying on the dance. The Belt and Road Initiative envisions the creation of 6 corridors, but these corridors pass through risky areas. I chose 3 cases of Xinjiang, Balochistan, and Rakhine since they are related with the development of 5 of these 6 economic corridors. Xinjiang is located at northwestern part of China. Its capital, Urumqi, is an important node in New Eurasian Land Bridge and China Central Asia and West Asia corridor. In addition to these two corridors, the land connection between Gwadar port that was built within China-Pakistan Economic Corridor is linked with Kashgar, which is an important urban center of Xinjiang region. Xinjiang region is comprised of 13 ethnic groups, but the major ethnic group is Uyghurs, which resented Chinese rule since the imperial time, and there have been 5 separate rebellions. The latest rebellion started in 2009. In 2009, 200 people were killed, over 600 people injured. Since that, there have been several bombing attacks that targeted Chinese security officials. The most notable was in 2016, Turkistan Islamic Party conducted a bombing attack in Chinese embassy in Bishkek, and it shows it can injure Chinese possessions along the Belt and Road corridors. Another troublesome aspect is the Uyghur militants who are currently fighting in Syria. Its number are reportedly reached 5,000. The return of these militants will clear up already tense situation in India. Balochistan is located in the southwestern part of Pakistan. Gwadar port, which China contributed over $40 billion to its construction, was built in Balochistan. Its population consists of Balochis, which resented Punjabi rule, and immediately after the independence, there have been 5 successive insurgencies. The latest insurgency has been going on for 13 years. Today's insurgency is very complex, having nationalist, Islamic, sectarian, and ethnic elements. Nationalist groups target Punjabis living in the region. To counter nationalist groups, Pakistan's security officials supported Islamic groups, but those Islamic groups now target Shia population in Balochistan. The development of China-Pakistan Economic Corridor also alienated Baloch population. Baloch nationalists fear the loss of control over land and ports. The huge amount of Chinese workers precipitated this fear, and radical groups have taken advantage of this situation. Islamic states conducted bombing attacks to Pakistan naval officers and kidnapped and killed Chinese workers working in Balochistan. My third case is Rakhine State. It is located at western Myanmar, China-Indochina Peninsula Corridor, and Bangladesh-China-India Myanmar Corridor are linked with Rakhine State. Kukyo port is the main port of Bangladesh-China-India-Myanmar corridor. It is also terminus of 1.5 billion worth of oil and gas pipeline to Kanin-Yaning region. It is plagued by the conflict between Rohingya Muslims and Buddhist majority in Rakhine. There have been rebellions after the independence of Burma. In 2016, about 90,000 people fled, and in 2017, approximately 1 million people fled to Bangladesh. And these attacks were carried out systematically. one of the victims interviewed stated that a Myanmar military official told them this kind of torture will continue until you leave. And the UN human rights official Al Hussein commented that this is the textbook case of ethnic cleansing. While this violence is also related with the development of Belt and Road Initiative. In 2012, only 17,000 acres were allocated for foreign investors. In 2017, millions of acres were allocated for foreign investment. This foreign investment is obviously China, and this is a bad news for people who are living on these lands. And although ARSA lost power, it continues to carry out attacks targeting Myanmar's security forces. Second part of my presentation is China's security measures to this conflict. In Xinjiang, according to Xi Jinping, Xinjiang is the battlefront against terrorism, and China increased its security budget and recruited more security personnel. Over the past few years, China has imposed an overwhelming surveillance system, which includes facial recognition systems, collection of DNA samples. Uyghur citizens are required to install applications which allow authorities to monitor their activities in online area. And over 1 million people were sent to re-education camps established in Xinjiang. This overextension of security measures, however, could be counterproductive as it carries risk of marginalizing even peaceful Uyghurs, and it may also await international sympathy for Uyghur case.
Sorry, we have very limited time. You can just go to the conclusion,
Okay.
like the concluding remarks.
Okay.
Very tight, I'm sorry.
Okay. The most important conclusion for China is that it abandons its traditional non-interference policies, since it actively intervenes in Balochistan and Rakhine State to counter insurgency in these areas, and it employs several tactics, traditional security measures, diplomacy, and promise of economic reward, but the long-term causes of grievances are not addressed, so the violence is likely to continue. Thank you.
So now, quickly, like few questions, like really quick, and then we, yeah. Oh wow. So really one question, please.
All right, quick. For Dr. Skala Kuman, you said about recommendation the European decision makers should get more involved in the BRI. Could you give some examples where you want to get them involved, how you want to get them involved, how do you see that, please? Then for Dr. Indeo, what's the added value for all these projects for Central Asia? Will Central Asia, and that's maybe also for the last speaker, is Central Asia, will that be the flyover country or the drive-through country or the rail-through country in the corridors, like they talk about the United States? What will be the added value for the Central Asian countries themselves and for the people there? How will they benefit? And then for Mrs. Wei, what is the main, according to you, what's the most important issue for international environmental governance in the BRI? Because I did not get it. So could you tell me which is the main issue in environmental governance in the BRI? Thank you.
Thank you. Short, you know? Yeah. So there in the back. You want yeah? One question only, please.
Is it possible to make comment? I am not
No.
great.
Only questions. Sorry. Sorry. Yeah. We go.
Thank you very much. I also had a question for
Professor Kurzman. I was so what is the obstacle the European decision makers not engaged in BRI? This is actually very similar. It's a hard question, but I want to know your opinion. Thank you.
Thank you. Then yeah, we go first in the back. We have like 2 more in the back, and then we come back to the front.
Thank you, Maria. I'm sorry to keep speaking. I think it's good to hear the voice from China when we are talking about China. So my question is for our last speaker. When we talk about non-interference, because my background is legal history, if we look back for the last 7 decades, we can see whatever regional conflicts or wars or some civil wars, China has never been involved in any kind of such events. But on the contrary, US, if not always, usually have been involved in all these events. And NATO, including many European countries, have also been involved. So how do you explain this? And another thing is, when I talked with...
One question, sorry. Move on to the next. I'm very strict.
Thank you very much. And my question to the Ms. Dr. Ying Liu. So during your presentation, you mentioned about that the Belt and Road, before the Belt and Road initiative announced by the PRC government, there is already a cooperation between all the energy infrastructure projects is already taking place in the region. And I mean that the main reason already the situation is these Central Asian countries have no choice without China. The Russian relation with Russia, with Central Asia is quite a difficult time before that time. And as you mentioned, Iran and Afghanistan is also creating a Central Asian country has no choice without China. So is that really the Belt and Road initiated or in how much has to take that? What's the extent that really the Belt and Road initiative has an influence on the Central Asian countries' energy infrastructure project itself?
Thank you. Eva, on the other side? Like there's 2 very quickly.
Yeah, very quickly, thank you very much. We all know that train transport is heavily subsidized, about 100,000 per train. So in Central Asia, we have doubts about the sustainability, profitability of current routes. What about the cost? Who will bear it for additional routes, and will it be profitable, and for whom?
Yeah, the last question, I'm sorry, because there's 2 more there. Last question.
It's a question for Dr. Indeo. In your presentation about Central Asia, you didn't mention the Shanghai Cooperation Organization. I don't know whether that was by oversight or because you don't consider it important, but bearing in mind that the original speech by Xi Jinping in Kazakhstan envisaged the Belt and Road as a specifically SCO initiative, including SCO members. It didn't go to Western Europe, and it didn't include everything that it now includes. You might want to consider the interrelationship between the 2.
Thank you. So I think each of you can just give a comment.
Okay, very shortly to the question of the response of EU and AU member states. So the only response we had so far was the establishment of the EU connectivity platform, coordinated by the DG Transport, so reducing the BRI to logistic and transport. So and there's still a coherent strategy lacking at EU level. I believe there could be 2 entry points. One would be with China in negotiating in the EU-China cooperation schemes we do have, and the second one would be to help the participating countries to benefit from the BRI and to include SDGs in the implementation. So in the more concretely, in the EU development cooperation, in particular in Central Asia and also Southeast Asia.
Thank you very much. And I can pass the mic. Yeah.
Okay, thank you for the question. Very quickly, benefit for people. I think that Belt and Road Initiative could spread benefit for people if China allow to Central Asian countries to commit their production in this corridor. As landlocked countries, they can find alternative outlets, market outlets in the Persian Gulf or also in the European Union. The problem is that the potentiality of to increase the production for Central Asian countries, excluding oil and gas. So the problem for Central Asian countries is to find some competitive goods to deliver to the European Union or to other markets, if exclude cotton, oil and gas. But of course it's the only thing, because we also observe during this day that the problem of the Belt and Road Initiative is that there is not involvement of Central Asian workers or Central Asian companies. So it could be a way to rebalance this Chinese presence in Central Asia. The second question, no choice, of course. Now Russia is weak to exert its geopolitical influence in the region. United States is trying to obtain some position in the region, but now China in the medium term, I believe that China is the real geopolitical winner in the region. And also the people opposition about the xenophobia or some kind of resistance against a perceived neo-imperialism of China could potentially hamper Chinese project in the region. The third question about the trains, the use of trains to reach the European Union is convenient in terms of days, because the trains along the Belt and Road Initiative takes 15 days, and by sea 35 or 40 days. The problem is that the transport by train is not so economic compared to the sea transport. But we should observe the development of railway corridors in geopolitical terms, because it's a way to diversify the export route to reach. Because if there is the problems in the Indian Ocean about potential, I don't know, political competition with Taiwan or the position of the United States, China is trying to develop different branches and corridors which allow to diversify and to be not dependent on a single route.
Thank you. We have to move on.
Okay.
Sorry.
Sure.
And we can have more discussions after.
Yes.
And you don't have to answer all the questions. I mean, just, yeah.
I think I have only one question. So I think to the question, what's the most important issue in international environmental governance? My view is that the implementation of international environmental agreements. That's it.
Quick response for China's interference is China is compelled to take an active stance because its high-value investments are at risk.
Thank you. So thank you so much. I'm sorry that there were so
Well, thank you. We will now have the concluding remarks by Professor Godemont. Professor Godemont is a celebrity in China affairs, former student of École Normale Revue, and then, of course, long-time professor at INALCO and Sciences Po. He established the famous Asia Center at Sciences Po at IFRI, Institut Français des Relations Internationales, and then an independent center famous for the expertise on Asia and China. He is now the director of the European Council of Foreign Relations program on Asia and China, and is also a senior associate at the Carnegie Endowment for International Peace. He's also a regular consultant of a European institution under the French Ministry of Foreign Affairs. So I would welcome here very warmly Professor Godemont to come this way to make his concluding remarks on the reality or not so reality of the BRI. Thank you, Professor Godemont.
Thank you very much. I was hoping desperately that your presentation wouldn't be too long because people are going to flee. I realize I'm the last person standing between you and a happy Friday evening. So I have either to entertain you or to shock you or to be very quick. I'm going to try to be a bit of the three, but not refrain from thanking the Leuven Center, Professor Wouters and Dr. Karai from bringing me there. I explained to them there were about 500 people who could do, or maybe 5,000, who could do keynote addresses on the Silk Road by now. So I claim no originality or exclusivity. Let's start. Figures. I gather it's been discussed a little by one or two of the interveners. We don't really know. Is it 50 billion? Is it 120? Is it 400? Is it even more? We get completely conflicting figures, explained also by the fact that some of the presentations even today say BRI covers 60 countries, others say it's 85. And really, my own take is everybody but the US and Japan. That would be more accurate, or it can be anybody but accurate, but the US and Japan. Is it investment or is it loans? Currently, there is this big fashion to talk about the debt trap and to say it's only loans. It's a lot of loans, but not everywhere. There are also big investments, and we have to disentangle the two because they have a very different reality. We've talked this conference, as usual, about the Silk Road, and I gather I wasn't there all day, but I looked at the tweets, summing up very well. At least one key point in each intervention. This conference was nuanced, balanced, much better, clearly, than a lot of the Silk Road hype or sometimes denunciation, less often, that we have. But as all conferences on the Silk Road, it's a Rorschach test. The Silk Road is what you want it to be, provided China agrees. That is how I would sum it up. And it means that we have very different visions. Just to mention today, a lot was in fact on the overland Eurasian complex and various routes. There was far less on the maritime road. China now also claims the Arctic. There wasn't much about IT and the cyber aspects of interconnectivity, which are currently being played out. Just today, China signs with Belarus and Thailand simultaneously agreements to launch Earth observation satellites, an Earth observation satellite with Belarus. They're doing that. We have to ask ourselves why. So the topic is even wider than this already wide conference. And of course, we have, that will be my second point, an extraordinary success of Chinese public diplomacy. Honestly, the poor European Commission had reinvented the Silk Road in the early 90s. In so many words in some of its papers, but unfortunately found the name of Traceka, which is clearly less evocative than that one road, or the Silk Road, to describe a program that was interconnectivity at its best, to facilitate communication, to try and erase somewhat the borders in Central Asia. And by the way, it's about to trot out another strategy for Central Asia, but I think is really due, and it will be very interesting to read it in, I gather, 2 weeks. It had happened. A lot of what is done under the Silk Road mantle, and some people have said it, had been done before. My fast rule about this is that the BRI incorporates almost everything that China does well. And this is what has been turned into an export product. China revolutionized its transports in the past 25 years. China remodeled its territory. It's now investing, and for the past 20 years, it has invested actually more in the inland areas than on the coasts, which are more dependent on markets. Everybody knows about overcapacities, but the overcapacities are only one aspect. The other aspect is that they do best harbor cranes. They are the only maker in the world. As I understand now, it's become a monopoly. Take an airport and go on the plank to a plane. You'll usually find it's Chinese now. They do excellent railways. When we remember all the bad things that were said about the Chinese fast train when it was inaugurated, I'm not talking about financial breaking even. That's another point, but they are not the only ones not to break even with fast trains. But in terms of quality, it's there. One thing we shouldn't underestimate, therefore, is the Chinese capacity to make projects, to make them fast. They're doing it for themselves, and they're exporting it. There were very good articles describing Chinese outward strategy through roads and trains 15 years ago already. So nothing completely new, but a systematization, a wonderful motto, and the attractiveness of potential investment. That is what has drawn partners, and this is, of course, where they are sometimes disillusioned by what is happening. A strategic move. I think there is overemphasis by some on the strategic purpose of the BRI as such, and China officially is busy denying it, if only by renaming it an initiative rather than a strategy. But there are strategic aspects. The maritime road is on them way before the land route, because the PLA follows the cargo ships, and because you can see it in the setting up of stops for the PLA, PLAN maybe, and bases, several of them, plural form now. Djibouti is the most indebted country relative to GDP because of China BRI link project. Unlikely that it will draw, because China is investing in a very serious military base there. This extends all the way to the Arctic Circle, all the way to Sweden where there was an attempt. So we should not underestimate, along with the rise in the military budget, the will of China to become a global naval power. That's what it clearly indicates, and it is part of the Silk Road, but it does not sum it up completely. The beauty of the Chinese hybrid economy is that you do have independent actors. Enough has been said, just 2 interventions before, about the difficulty to control them, about trying to check corruption, about to check fraud, that we understand that a lot is happening besides official design. There are therefore stages in the history of DBRI. Just this week, Monday, we had a speech by Xi Jinping on the past 5 years and what's coming ahead. Trying to read the speech, I frankly don't find a lot of very telling detail or outline on what's going to happen. My take, because of that, is rather retrenching a little, like what has happened for outward investment, reading in very big projects, emphasizing much more the human component, emphasizing stuff that somebody mentioned it too, and by mentioning hospitals, and we should not forget the Chinese talent for ODA, for overseas aid, and for human aid. This is also something that was 50 years back, by the way, and that challenges Western aid conceptions, because the Chinese have the manpower to do these things, and they are doing it. And then there are those marvelous words in Xi Jinping's speech of Monday, that this is also according to the heritage of the great harmony under heaven, Tianxia Datong, an imperial term which is extraordinary in the middle of a retrenching speech, which shows that in ideological terms, or in historical terms, or in political terms, the Silk Road of the BRI can still become anything, depending on circumstance, including the grand Chinese design, which I hasten to say is not yet fully there. 3, and this will immediately involve Europeans, the question of norms, rules through BRI. Well, Europe, like Japan, is a kind of paradise for norms and rules. We probably have more than anybody else. There are populist revolts against that. The US is retrenching, so we may be sitting at one extreme of the scale. But China and the BRI often emphasizes developing economies and has success in construction in developing economies, is at the other end of the case, and therefore we clash with China over norms. This is very important for Europeans for two reasons. Because if the Silk Road is to really arrive other than with carriage trade, but with projects, infrastructures, and become a successful competitor in European public markets, not only is there an issue of reciprocity, but there is an issue of norms. Not clear at all that China is willing to make a sacrifice for Chinese firms to adapt. And the second problem we have for Europeans is that if you're Chinese and looking at all this, well, you figure out you still have a 6% growth rate. Europe is around 2%. The rest of the world is going faster than Europe. So why don't you just go around Europe? Let Europeans live in their parallel universe of norms and conquer the world without those norms. That would be a huge setback for a term that is comparatively recent. 40 years ago, Japanese ODA and projects were not completely dissimilar from China does today, but the world was different. It had less scope, it mattered less politically. Today, in a globalized world, this is a much more important issue. So we have this problem. One of the interventions today mentioned the need to engage the Chinese directly on BRI and to participate in the project. I think we all swarm to AIIB like bees swarm to a honeypot, not realizing that AIIB was just one aspect, one institution among many others. AIIB is the model institution where China in fact learns and practices international and global norms. The other funding institutions are much more completely different. I looked and I may be out of date because this was three or four months ago. 3 or 4 months ago, the number one project funded by AIIB, and I couldn't believe my eyes when I saw it, was actually an east to west pipeline from the Caspian through Azerbaijan and Turkey that will ultimately feed into the Greek and Italian gas market if the Italians accept the environmental consequences of the pipeline, which is not even sure today. It's completely counterintuitive. 700 million euros, it's something. It shows that this institution is special. This is the facade that in fact does work well, but that is not synonymous with the overall project. We must pay attention to that. Finally, I think we have to repeat what at least one of the persons that I listened to mentioned, which is the big gap between multilateral gloss and bilateral decisions and action. It's unavoidable because the Chinese system of foreign relations always worked in this way, with an overall legitimizing canopy and a long practice of international organizations, first in a very defensive way, and now a little more actively. And behind this, always believed in very pragmatic bilateral relationships. But we should not confuse the two. This is one problem with the MOUs on the Silk Road, on the BRI. Read any of these MOUs, they read alike. One could almost write one with country X or international organization Y, because they're full of the same mottos, which mean they are not revealing. They're just statements of intent about, yes, we cooperate, we agree with you, and we subscribe, at least on this, to your worldview. The offensive with the UN has been particularly strong, and that makes me comment to you even more the UN report that just explained that 1 million Uyghurs in Xinjiang are currently interned incommunicado, waiting for a lot of confirmation of this, but there are a lot of telltale signs, because that's a good sign of independence for UN organization in a system that has been largely taken over in terms of legitimacy by the Chinese. Never mind why there are other reasons if others retreat, starting with the US, obviously an active power like China will move forward. But we should not forget this gap. I am, and I will stop there, extremely glad that part of the presentations that I've just glimpsed at or heard snippets at went into case studies, into what's actually happening on the ground. I would say, if one wants to learn about the BRI, just as if one wants to, this is an axiom I had several years ago for Chinese policy in Africa, don't go to Beijing. Go to African countries or go to the receiving countries to see how it's perceived, how it's done on the ground. People in Beijing will tell you, general things and general lines and will be miles away from what's really happening. And this is, of course, also why the Silk Road, I've tried to provoke you by describing the mythical aspects, but that's why it's also a reality, or rather several realities. I will stop there. Thank you.
Time for a few questions.
Yeah, absolutely, yeah.
So, well, first ago.
Thank you, Chairman. I really enjoyed the speech by Professor Godimon. I fully agree with you that you read most of the Chinese documents, most of them tend to be grandstanding with little or no substance. You also mentioned this speech given by President Xi earlier this week at the 5th anniversary of the BRI. But I thought at least one part of this speech was very interesting. When President Xi mentioned that, when the project was first started, it was like big strokes, what he called 大协议 in Chinese. And now we have to move on to what he called 工笔画 or fine sketches in the BRI initiative. So I thought that he was probably realizing that this way of just going everywhere and trying to go after every possible project in all these countries simply doesn't work. And China needs to narrow down into specific projects, and probably more importantly, to do evaluation of the cost and benefit of potential projects. Because he also mentioned, and in his speech he said we have to pay special attention to the risk analysis of some of the projects. And this apparently was not really mentioned in previous speeches. So I thought that might be a sign that the Chinese government realized that the old approach of simply throwing money at everybody who comes to your door doesn't work anymore, and they want to probably do more. And probably in the near future we will see more detailed outlines from the Chinese government as to where they want to focus and which project they want to focus. I was wondering what are your reactions? Thank you.
Another question, maybe.
The captain is also really upstairs.
Sorry?
The captain is really upstairs. Just very, yeah.
So, question or no question?
One more question? If it's really a question,
Just in the middle there. Just one question for Professor Godemont, because he said that on one extreme there is the EU about a lot of rules and technical norms and so on, but the Chinese industry is in the learning stage, and BRI and their vast domestic market enables them maybe to create new technical standards. Once they have done that, maybe they will also move to creating their own rule that they'll try to impose on the rest.
I just want to ask a quick question regarding the European Commission. It released a consultation document in February. Opinion on EU strategy on connecting Europe and Asia, which is expected to become official EU policy in October, which is also discussed in the second panel by one of the professor, which is meant to give the developing countries an alternative to China's BRI. I'm just curious to know about, is it like cooperate with BRI or it will be an like separate project? Thank you.
Okay, thank you. No, we let Professor Godemont finish because we accept no more questions.
In the interest of everybody.
Yes.
First question. I've been struck like you. Criticism inside China on the BRI or on OBOR, as it was called, has always been rampant. You know, money spent elsewhere. Where is it going? The Pakistani aspect, for example, was particularly criticized inside China. And it was not difficult even last year to read stuff by researchers affiliated to the State Council, to research units affiliated with the State Council, saying this energy road through Pakistan doesn't make any sense economically or perhaps even geographically or geologically. It's been dangerous. So with what has been happening, several countries saying, you know, you're too expensive for us, or you overcharge in terms of interest rates, or we can't afford it. It is time for retrenchment. It is time for modesty, for more modesty. And I like to think that Xi Jinping, in spite of his elevated position, has understood some of the risks in the overhyping of the Silk Road. He may also have understood, because recently there's been this idea to completely underplay China Industry 2025, that the more you hype the Silk Road, the more you worry competitors and partners about the ultimate strategic aim. So unclear to me just from one speech what will happen, but I think we have to ask that interrogation about retrenchment, fine-tuning, more human elements. The one big failure, I think, in almost all of the OBOR BRI projects up to now is once they work, they always work well in terms of infrastructure, but the accompanying investment, the accompanying soft presence usually hasn't been there. Others do better, including Asians, the Japanese, for example, or the Koreans, do better to balance the two. So there could be something happening. I didn't go as long as I would have liked to on norms. I just outlined a small part of it. I think the other virtue of China's presence in UN committees, for example, either at ESCAP or at UNICE, is to work on norms. For example, they're trying to change BOT, build, operate, transfer norms. And it's interesting that they do it in a committee that's nominally European, but in fact not controlled by the EU. I think there's a definite effort to balance and eventually to shift or to go around the EU rules, and that is, of course, preoccupying. There is a big difference, however, with succeeding in developing economies and succeeding in the big markets. And that's the limit for the Chinese. So I've sometimes met with colleagues or read stuff among experts, at least, I don't think it goes more, in China, which does say it is in the interest of Chinese companies to learn to practice these other norms that we don't know about if we're serious, long-term, about such a thing about the European market. But for that, you also need self-confidence among Europeans, which will lead me to the answer to your third question. I obviously haven't read the strategies that are about to come out for the European Commission, but I can tell you what I feel is necessary. I didn't badmouth Trasica and the precedent of the early 80s. My only comment is because there was 1 0 missing on the financial side of the project. It is crucially important that we're able to present either evaluations and training about rules and training about how do you launch public projects, how do you review them, how do you evaluate them, how do you control them with third countries. It is crucial that we present financial alternatives to the kind of open-ended Chinese credit financing, which has its advantages. It's there, it's a spigot, but on the other hand, it's also a dependence afterwards. One idea, for example, would be for the one dirty little fact in financing by China of big infrastructure projects, it's often projects that wouldn't be financed by others, including inside or in the neighborhood of the EU, just because they won't necessarily break even. Sometimes we make mistakes. I understand there was a very good presentation on the Kenya, Rwanda, South Sudan, Tanzania interconnected project. I think it's fantastic.